Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
Good morning, everybody. My name is Alexandra Tratnik, and I'm associate with Devry, Smith & Frank. I've been with the firm now for about 2.5 years. My practice primarily includes commercial litigation, debt recovery. I do some family law and employment law, and of course, employment law. I've been asked to speak to you today about the recent Ontario Superior Court decision, Hussain versus Suzuki Canada Limited, and the implications of this case has to what some refer to as the 24-month cap on reasonable notice. To limit costs and litigation risk, it is important for employers and their human resource professionals to know the law when it comes to firing employees. Generally, as discussed previously by Bill, to terminate employment without just cause, you can do so provided you pay reasonable notice or if you provide reasonable notice or pay in lieu thereof. A main reason for the notice requirement is to allow employees sufficient time to locate and secure alternate employment. Again, as Bill has mentioned, while the Employment Standard Act sets out the minimum notice period requirements, case law dictates what will be considered reasonable in the circumstances. Again, Bill covered this as well. The leading decision in Barber, as discussed by Bill, states that the reasonable notice periods are decided with reference to each particular case having regards to certain factors. Those factors are listed up there again for you. Failing to provide reasonable notice could make an employer susceptible to wrongful dismissal action and liable for damages. Because the ESA only provides the minimum requirements, determining what constitutes reasonable notice is a vital step to mitigate against the possibility of litigation by employees who may be entitled to more notice than what is provided for in the ESA. While there is no express threshold on the length of reasonable notice, Canadian courts have typically held that the base notice period will be 24 months, except where punitive or aggravated damages, for example, bad faith, are warranted. It's only what's called exceptional circumstances that a court will award a longer notice period. These principles were reaffirmed in the Ontario Court of Appeal 2006 decision of Lowndes and Summit Ford Sales Limited. In Lowndes, it was a 59-year-old general manager of a car dealership who was fired after having worked for the company for almost 28 years. At trial, he was awarded 30 months of reasonable notice plus an additional 4 months notice to reflect certain bad faith conduct engaged by his employer at the time of his termination. The employer appealed the decision, arguing that the notice period was excessive and ought to be overturned. The employer was successful at the Ontario Court of Appeal, and the court reduced the base notice period from 30 down to 24, and found that the circumstances of this particular case were not exceptional. Unfortunately, the Court of Appeal failed to discuss really what would be considered as exceptional, so this left employers kind of hanging. Over the years since Lowndes, employers have continued to typically cap reasonable notice damages at 24 months, even for the long-serving employees. However, a recent 2011 decision of the Ontario Superior Court departs from this norm and gives us a glimpse into what circumstances might be considered in Ontario as exceptional. In Hussain and Suzuki Canada Limited, the employee was 65 years old, and he had been employed with Suzuki for almost 36 years. This was one of his only full-time jobs in Canada, and it encompassed his entire working life. Suzuki let him go due to corporate restructuring because they were facing financial circumstances. The employee argued that given his extraordinarily long service, his level of importance, and his expectation of retiring with Suzuki, he was entitled to 30 months' notice. While the court acknowledged that 24 months' notice tends to represent the higher end of damages for wrongful dismissal, the court found in this case that given the employee's age, length of service, and lack of job prospects, there were exceptional circumstances warranting a notice period of 26 months, which is higher than the norm. In reaching its decision in Suzuki, the court considered the following factors. They're listed up here, but I'll read through them in case you can't see that. The fact that the employee was 65 years old, the fact that the employee had worked for Suzuki continuously for almost 36 years. He was Suzuki's longest tenured employee in Canada, and there was no inkling that he would be terminated. The fact that the employee had worked his way up to the position of assistant warehouse supervisor, supervised 11 employees, and to which the employer admitted was a very important and valuable job. The fact that the employee was dismissed from his employment due to Suzuki's corporate restructuring as a result of economic hardship. The fact that the employee's skills were general skills obtained on the job, and that the court found that they were less marketable than skills than a product of a definable trade. And while there was no evidence that he intended to retire in the near future, the court found it was a reasonable inference that the employee was closer to the end of his working years. The court went on to say that while each of these factors may not be exceptional in and of themselves, the combination amounted to the kind of exceptional circumstances that warranted an extension of the notice period. This decision is noteworthy for a number of reasons. First, the court awarded a lengthy notice period despite the non-managerial and relatively junior position held by the employee. The fact that the employee was nearing the end of his working years served to increase rather than decrease his notice period. And in recent decisions, termination as a result of restructuring due to economic hardship has actually resulted in a reduction of the notice period. However, this was not the case in Suzuki. So the implications for employers of this case. Employers should do away with expectation that the base notice period obligations are capped out at 24 months. As the population ages and remains in the workforce longer, due in part to the abolishment of mandatory retirement, employers may face increased burdens when terminating a long-standing employee. What makes the particular circumstances in Suzuki exceptional is not quite clear, and the line between what the court considers normal circumstances and exceptional circumstances is not easily distinguishable, and this causes uncertainty. While I find that it's unlikely that there will be a flood of decisions exceeding this 24 months notice cap, this uncertainty will create pressure in negotiating termination packages to push this limit. As well, the character of the employee's position, whether it be supervisory or executive, skilled or unskilled, no longer appears to carry the same weight as it once did to reduce the notice period for employees holding lower level positions with the company, as Bill had mentioned previously. Another noteworthy thing to take from this decision is that it highlights that, contrary to the assumption of many people and employers, it cannot be presumed that an employee who has reached the age of 65 would be retiring in any event, and therefore the employer can fire an employee without providing reasonable notice or pay in lieu thereof. In the post-mandatory retirement era, employers should consider the potential liability for terminating older and long-serving employees. An attempt to save money on termination packages could end up being very costly. Employers should not necessarily assume that older employees intend to retire at a certain age when you're considering the appropriate notice period. Suzuki also underlines the importance of having a well-written employment agreement with fair, enforceable termination provision. If you have one of these, you can avoid, exceeding this 24-month notice cap. Finally, it is prudent for employers to speak with a lawyer to ensure that they consider all of the possible options when terminating older and long-standing employees. These options include providing working notice or a severance arrangement subject to mitigation to ensure that you take the best approach to reduce your costs and limit exposure to litigation. Thank you very much.